and welcome to another session of Current Legal Affairs by CLAT Point. Now, these are the batches that go on in CLAT PG, and we have several batches for 2023. Please contact and get yourself enrolled in one of these batches. We take live classes, we take recorded classes, study material is provided to you. There's a series of mock tests for, the more you practice, the better. And this year has been incredible. We have had a lot of selections, as you can see, more than 50 selections by CLAT Point itself. So, any queries that you have, you can please contact on this number. And now we move on to the legal affairs for this week. So there's this first case of Amshed Adil Khan versus Union Territory of Jammu and Kashmir. Now this judgment has been given by the Delhi High Court. And what does it say? So what this judgment is saying is basically what is already stated in law. And there is nothing new which is being said. However, the point which is being emphasized on is really important for your exams. So what does it say? The court has said that from the plain reading of section 160 subsection 1 of CrPC, it is evident that for the purpose of investigation, a police officer can require attendance of a person situated within the limits of his own police station or that of the adjoining police station and not someone who is situated beyond the territorial limits. Now, under section 160, the police can actually call in, witnesses for their statements, for, investigating a case. The court further says that by a merry reading of the said provision, it becomes apparent that the power of the police officer to require attendance of a witness is circumscribed by words within the limits of his own or any adjoining station. So what the court means to say here is that this section, if you read the section, it is saying that there is a certain limit from which the police officer can actually call a witness to give the statement. It is not that all over India, from anywhere, the police officer can call in, right? It is restricted, it is circumscribed to within the limit of his own, that is in the own where the police station is situated, the jurisdiction of that, or adjoining stations. It is to be noted that if the said power was in the nature of pan-India power, that is, if it applied to like whole of India and a police officer can call in anyone from any part of the India, as has been sought by the argued respondents in this particular case, there was no reason for the legislature to use the terminology quoted above, right? Now, the court is saying that if legislature has used this particular terminology, that, his own police station and the adjoining police stations, then that means there is significance to it and it does not include pan-India. It does not include whole of India. To the contrary, if the same was the intention of the legislature would have clearly stated and bestowed unlimited jurisdiction to the police officer by using the terminology in the nature of anywhere in the country. That is what the legislature would have said, or anywhere within the state. So the court is saying that the police officer does not have power even in the whole of the state. The territorial limitation is pretty much to his own jurisdiction, the police station's jurisdiction, and the adjoining ones. The clear departure of the legislature and the use of terms within the limits of his own and any adjoining station points towards a legislative intent to limit the jurisdiction in this regard. Now, there is a very basic rule of interpretation in law which says that if something has been clearly stated in the legislature, then it has to be interpreted in that very manner. And the courts do not interpret it in any other manner. However, if the language of the legislature is ambiguous, it is then that other resorts are taken by the court. Otherwise, what is written, if it is clear, the court sticks to that. Now, what does section 160 say? Police officers' power to require attendance of witnesses. So when a trial is going on, when an investigation rather is going on, the witnesses can be called in by the police officer, and they can be required to make statements, and they can be asked certain questions, etc. So that is what this is pertaining to. Now we come on to Fayaz Ahmad Sheikh versus Mustaq Ahmad Khan. Now this is a judgment by Jammu Kashmir and Ladakh High Court. Now what is the case here? So there was a person who had given his check, and the check had bounced, right? Very simply. Now when a check is bounced, the basic case that is filed is under section 138 of NI Act, right? You can read here. Section 138 of NI Act says dishonor of check for insufficiency, etc. of funds in account, right? So these are the check bounce case. Another is under section 420 of IPC, right? So what does 420 say? It is cheating and dishonestly inducing delivery of property. Now the check is actually a property, right? Because it is a valuable which can be converted into money, cash. So it is a property, right? Now the court observed that offences under section 138 NI Act and section 40 of IPC are distinct from each other because ingredients of the two offences are different. In prosecution under section 138 of NI Act, fraudulent or dishonest intention at the time of issuance of check need not be proved. But in prosecution under section 420 of IPC, such intention is an important ingredient to be established. Now, why did the court say this? What happened? So there is a concept of double jeopardy. I'm sure you all must have read it. It is under Article 20 of the Indian Constitution. What does it say? It is also under Section 300 of CrPC, right? But as we can see, because it's under Article 20 of the Constitution, it means it's a fundamental right, right? Double jeopardy simply means that if one person has done one act which is an offense, for that particular act, for that particular offense, one person can be punished only once, right? So if, for example, a person has been convicted or even acquitted under section 138 of NI Act, another person or the same person on the same facts, on the same on the very same situation cannot go and file another case for the same against the same person. So for example, A and B, right, they have been given a check by C. Now the check has bounced, right? They file a case and A and B win the case. C has been, convicted, and whatever punishment had to be given has been given. For example, he has been given imprisonment. After a few days, A goes to the court again and says that, you know what, I'm coming again under NI Act of under section 138, and I want that now C should also be given fine, because earlier he was only given imprisonment and there was no fine imposed. The court will say that now double jeopardy is applying because C has been tried on that same facts, against the same law, against the same offense already, and he cannot be tried again on the same facts, right? However, the court is saying here that section 138 and section 420 of IPC, they are not the same. So if A and B go again to another court, and they to a criminal court, of course, and they file a case under 420, right? And they say that, you know what, the NI court has given the judgment, and C has been convicted, but we also want to hold him liable under section 420. Now C cannot say that the rule of double jeopardy is applying. Why? Because the court is saying that section 138 and section 420 are actually very distinct offenses. And double jeopardy applies only when the offense is same. If the offense is different, you cannot say that, you can't punish me, right? So this is why this whole thing is being talked about, and double jeopardy is a very, very important concept, and it applies in all the democracies of the world. So now here is what the court has said, quote unquote. The fundamental right, which is guaranteed under Article 20, Clause 2, enunciates the principle of autrefois convict or double jeopardy. That is, a person must not be put in peril twice for the same offence. For one offence, he cannot be put in peril twice. That is, he cannot be put into trial twice. The test is whether the former offence and the offence now charged have the same ingredients. This is the main thing that has to be looked for, in the sense that the facts constituting the one are sufficient to justify a conviction or of the other, and not the facts relied on by the prosecution are the same in the two trials. A plea of autrefois acquit is not proved unless it is shown that the verdict of acquittal of the previous charge necessarily involves the acquittal of the latter. That is, if the person is saying that, under section 420, A, B, C needs to be proved to prove that I am the one who is guilty and I should be convicted. A, B, C ingredients have to be proved. Now under 138 also, A, B, C are the ingredients which are to be proved, and this has already been proved and I have been acquitted. So now they will be, these people will go on and again be proving same ABC for section 420. This is in vain. I cannot be telling myself that in front of the court, that I have done no offense for the same set of facts again, for the same ingredients again, for the same offense again. If the ingredients are same, if again ABC has to be proved, then double jeopardy will apply. If it is DEF which needs to be proved here, DEF are the ingredients which need to be proved here, then these two do not equate each other, and therefore double jeopardy does not apply. So even though a person has been acquitted or convicted under 138, he can still be put in trial for section 420 of IPC, right? Now we move to Amita Garg versus State of UP. This is by Allahabad High Court. Now this is a rather new concept. What does it say? It talks about transit anticipatory bail. Now what is a transit anticipatory bail? Firstly, whenever you see the word transit, what does transit mean? Transit means in motion from one place to another. It's moving. It's moving from some place to another place, right? An anticipatory bail is something that you have the definition under section 438 of CrPC. But transit anticipatory bail has nowhere been defined in law, right? But what does it mean? It means that a bail granted by a court not having jurisdiction over the place where the offense was committed. So, A is a person. He can, be arrested. He is apprehending arrest in, let's say, Lucknow. That is UP, right? But he is, let's say, in Kolkata. He is residing there, or he is there at that point. And he is thinking that, in UP, there can be a case against me. I am apprehending arrest and I need anticipatory bail. What is anticipatory bail? When a person is anticipating apprehending arrest in a non-bailable offense, then he can ask for anticipatory bail from the court. Now this person is thinking that, I am in Kolkata, but the UP police will come in here in West Bengal, Kolkata, and they can arrest me. If I go all the way to Lucknow and ask for anticipatory bail, most likely while I am in, my journey, I'll be arrested. So again, I won't be able to reach the court and ask for anticipatory bail, right? Or as soon as I reach there, they will arrest me. So once a person is arrested, they cannot file for anticipatory bail because there is no anticipation now. It's actually an arrest, right? So what does he do? That he goes to the Calcutta High Court itself. And in Calcutta High Court, he asks for anticipatory bail. Now Calcutta High Court does not have the jurisdiction, right? Why? Because a crime has been committed in Lucknow, right? And which court has the jurisdiction? Where the crime has been committed. So Calcutta High Court has no jurisdiction. But Calcutta High Court can grant him anticipatory bail this anticipatory bail will be called transit anticipatory bail. While the person is in transit, this anticipatory bail will hold true. Now he has to go to Lucknow, and in Allahabad High Court or Lucknow bench, whatever, he has to file for anticipatory bail. Only till that point of time, while he is in transit, will this anticipatory bail given by Calcutta High Court be actually functioning, right? It will be valid. Once he reaches there, goes to the Lucknow High Court or Allahabad High Court, wherever, and asks for bail, anticipatory bail. If that bail rejects, if that High Court rejects the anticipatory bail given by Calcutta High Court is cancelled on its own. He cannot say that, you know what, Calcutta High Court did give me anticipatory bail, so arrest to mujhe nahi kar sakte ho. No, you cannot say that. Why? Because this is the court. This is a jurisdiction which is actually having power to give anticipatory bail. And another jurisdiction by Calcutta High Court was only during the period of transit. I hope that you have understood the concept. Now, what has the court said? That there is no fetter on the part of High Court in granting a transit anticipatory bail. That is, nowhere in the law is it being said that a High Court cannot grant transit anticipatory bail. To enable the applicants to approach the court, including High Courts, where the offence is alleged to have been committed and the case is registered. So, this is a very logical end. Why? Because if a person cannot reach the place where he can ask for anticipatory bail, essentially we are depriving him of his, of a right, of a statutory right which he has been given, right? So just to protect his statutory right, this transit anticipatory bail ka provision is in practice. Now, this is an example which Nupur Thapalia has given in her article. It's a nice one. It is similar to this, that A is a resident of Punjab and has been apprehending that a case might be registered against him in Delhi. In a normal situation, A will have to travel to Delhi from Punjab in order to get bail, as the Delhi High Court is empowered to grant the bail, right? However, if A is apprehending arrest by Delhi police within Punjab jurisdiction, Delhi police will come in Punjab and arrest him. He can move a court in Punjab seeking anticipatory bail. So in Punjab itself, he can ask for anticipatory bail. The local courts granting transit bail has limited protection. Now, this is a very limited protection which is given till the time accused approaches the jurisdictional court for bail, right? Now, the case, a very famous case on this is Nikita Jacob versus State of Maharashtra, and the second is Javed Anand. These two cases are the important ones, right? Essentially, they have said the same. So, I have quoted Nikita Jacob versus State of Maharashtra from Bombay High Court. Now, what did the court held? Temporary relief to protect liberty and to avoid immediate arrest can be granted by this court. Generally, the powers of High Court in anticipatory bail applications are limited to its jurisdiction, to its territorial jurisdiction. However, as observed in the case of Javed Anand, there may be cases where if protection is not granted, liberty of an individual would be jeopardized. Why? Because liberty is protected under Article 21. The real case of making application under Section 438 is proposed arrest of person. In the present case, there is strong apprehension of the arrest. So basically, that was as per the case. The thing being that apprehension of arrest needs to be there even in case of transit anticipatory bail, right? That is it for this particular concept. Now we come to State Bank of India and others versus Dr. Vijay Mallya. Now this is a Supreme Court judgment which has been given. So what has happened in this is basically Vijay Mallya has been upheld for contempt. Honestly, this judgment is not all that important from the point of view of exam, but the concept of contempt of court is important, right? So let's just read a bit what the court has said verbatim, and then we'll go on discussing the law. Considering the facts and circumstances on record and the facts that the contemner, that is the one who has contemned, never showed any remorse nor tendered any apology for his conduct, we impose sentence of 4 months and fine of sum of rupees 2,000 upon the contemptor. The fine shall be deposited in the registry of the court within 4 weeks, and upon such deposit, the amount shall be made over to the Supreme Court Legal Services Committee. In case the amount of fine is not deposited within time, the contemptor shall undergo further sentence of 2 months. Right? Now let's see that what is actually contempt of court. Now Contempt of Court Acts 1971 is the main law which guides the whole law of contempt of courts. Contempt of court can either be civil, right, or it can be criminal. There are two kinds of contempt. Now what's the definition? Section 2B of the Contempt of Courts Act 1971 says that civil contempt means willful disobedience of any judgment, decree, direction, order, writ or other process of a court, or willful breach of an undertaking given to a court. Now what does it mean? Let's say there was a case between A and B. It was a property issue. The court held that A has to give the property to B. The judgment has been given, but the decree has been awarded, but A never gave the possession to B. He still stayed there. He did not give any papers and he did not do as the court said. What is the option with B? B goes to the court and says that, your lordship, you passed the judgment, but A doesn't comply with it. So what is he doing? He is in contempt of the court. The court has said something. The court of law has asked you to, do a certain thing and you're not doing it. So therefore, you are in contempt of the court. That's a civil contempt. Now comes the criminal contempt, which is under 2C of Contempts of Court Act. What does it mean? Is attracted by publication, whether by words spoken or written, or by signs, or by visible representation, or otherwise. Now this is exactly the language we read for defamation. Of any matter or doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or interferes or tends to interfere or obstruct or tends to obstruct the administration of justice in any other manner. Right? If you have written or anybody has written anything against the courts which have this effect, any of these three, then the person has done a criminal contempt. Right? Now, what does section 15 say? You must have read in the news that at times the Advocate General has not given the permission, or like a notice has been given to him and he has not agreed that yes, a contempt may be filed. Right? So, who gives him this power? Let's see. Under section 15, cognizance can be taken by Supreme Court and High Courts in the following manner of contempt of court cases on its own motion. So the court on its own sees that something against us has been written which is having this effect. It scandalizes or has prejudice or interferes in the obstructs the administration of justice. Or on the motion of Advocate General sees that something has been written or somebody is not following what the directions were given by the court. On the motion of any other person, so any other person can go with the motion, but with the consent in writing of the Advocate General. So some XYZ person goes and says in rather things that this particular article which has been published, or this particular film or series or anything, is actually against the court and it will interfere in the administration of justice. And he wants to file a case of contempt. What will he have to do? He'll have to move a motion with the consent of Advocate General. So he'll have to seek the permission of Advocate General. On the motion of such law officer in relation to High Court of Union Territory of Delhi, as the central government may notify. So in case of Union Territory of Delhi, the central government can notify any other special officer other than the Advocate General. And in that case, the person has to comply with the special notification. So only after Advocate General allows can a person go ahead with filing of a contempt petition. So this is all, and this is important, the difference between civil and criminal contempt, which is why we have covered this case. That has been all for this week, and we hope that you understood all the important cases and the law related to the same. Thank you so much. Have a great day. Bye bye.